Thanks for telling me the questions I should ask. You will have your opportunity at the end
Just
of my
shut up and move
questioning.
on with your questions, okay?
Mr. Curry.
Just shut up, or I'll adjourn this deposition, and you can tell it to the judge, or I'll get you some tissues and you can cry.
Mr. Curry.
All right?
Please don't tell me what to do.
You
with
asked him
deposition.
if he ever spoke with Farsh about anything. He said no. Now you're asking him to tell you what Farsh told him. It is a bullshit question. It is absolutely speculative, no foundation, or anything else. Now, he's entitled to a fair question. You told him that. So if you're going to sit there and ask unfair questions, I'm going to correct them. So I don't waste this guy's time having to come back or go to trial and undo the mess that you're trying to create. Got me?
Are you finished?
Are you finished?
Are you
Do
aware?
you understand the question,
Are
Mr.
you aware
Schiff?
of the local rules with
Foster?
regard to what objections you're allowed to make and what
Do
you're
you
not?
understand the question, Mr. Foster?
Sir, right now this is my witness. I get to ask the questions. You get to make objections only. There are two types of
Call the
objections
bailiff.
you can make. Objections
Call
to
the
form.
bailiff.
Sir,
Do you understand the question being asked, Mr.
Mr.
Foster?
Curry,
Don't ever presume that you get to tell me what to do or when to do it, counsel. Don't you ever presume.
Why
Mr.
should
Foster,
you be
this is
entitled-
your deposition. Do you understand the question?
why should you be entitled to then tell me what to do? Doesn't it go both ways?
Because I'm being straight with the guy and you're being not straight with the guy. That's why. He has no dog in this fight.
Are you finished giving your opinions now about
He
the
has no
question?
dog in this fight, and you're trying to get him to say things that are simply untrue. It's an old trick, Mr. Zohar.
You don't think you're
Okay.
trying to coach the witness right now?
I'm telling him what the question is so he can answer it.
Do you know what speaking objections are?
Don't lecture me, idiot. I'm telling you I'm not gonna let that happen. Okay? You got me? Do
I
we
wanna
understand
know
each other?
if you understand the
Are we
rules.
connecting here? Because
I'm
if we're
trying
not
to
connecting
proceed.
here, I will try again. Okay? Don't give me local rules, don't give me procedures, don't give me professionalism. Just put a fair question to the witness. And if you're not going to do that, then I am. We understand each other?
If you believe that a question that I ask is not proper, then you get to pose a valid objection. You're not allowed to make speaking objections. You're not allowed to give your
Don't lecture me,
opinions.
puppy. Don't lecture me. I was doing this when you were still chasing cheerleaders. Don't you even think about lecturing me about depositions.
I think you're practicing a few
So-
years more than me, actually.
so-
That's it,
so-
to be honest with you.
Do you understand the question?
Mr. Curry,
Let's have the question right
it is
back,
my
please.
desire to follow the rules. If you don't believe we should be following the rules, then maybe you need to explain to me what procedure we are supposed to follow.
Now, do you think that there's anything wrong with adding Testmaster students who you met only by virtue of your employment at Testmasters to a prospective client file for your competing company?
Would you read the question back, please?
Now, do you think that there's anything wrong with adding Testmaster students who met only by virtue of your employment at Testmasters to a prospective client file for your competing company?
Object to the question is no foundation. It calls for speculation, seeks a legal conclusion, it's argumentative, and I'm instructing the witness not to answer.
Mr. Tatey, do you think that it would be improper for you to copy your employer's course material while you're a Testmasters instructor and use it for a competing business?
Same objections, same instruction.
So as we sit here today, you don't know whether or not it's a true statement that as of March 30th, 2005, Blueprint had not yet finished the writing and production of its LSAT course.
Objection, argumentative, also invades the attorney-client privilege and the work product doctrine, instructed not to answer.
Do you deny, Mr. Tatey, that as of January 12th of 2005, that Matt Riley was a Blueprint partner?
Objection, same objections, same instruction.
Mr. Curry, this goes to the very heart of the case here, and I'd ask you to reconsider your instruction and allow Mr. Tatey to answer this very simple fundamental question.
I've reconsidered. The answer is no.
Can you rule out the possibility that Matthew Riley was a Blueprint partner while he was still teaching for Testmasters?
Same objection, same instruction.
Do you deny that Matthew Riley was a Blueprint partner at the same time that he was teaching test masters classes.
Same objection, same instruction.
Do you deny that Matt Riley was working on the Blueprint website while he was still teaching classes for test masters?
Objection, it's argumentative, calls for speculation, there's no foundation, instruct the witness not to answer.
And can you say with certainty that Mr. McCarthy did not help in any way in helping Blueprint create the course material?
Objection, calls for speculation, no foundation, it's argumentative, instruct the witness not to answer.
Do you deny that Courtney Martin was working for Blueprint on its website while she was a test masters instructor?
Objection, same objection, same instruction.
Were you trying to get Courtney Martin to do work for Blueprint while she was a test masters employee?
Objection, vague and ambiguous. You can answer if you understand the question.
I don't believe that I was.
Do you deny that you were?
Objection, asked and answered, argumentative, no foundation, calls for speculation, instruct the witness not to answer.
Now, why around this time period did you want to damage Robin Singh?
Objection, calls for speculation, no foundation, it's argumentative, instruct him not to answer as phrased. Okay, that's it.
Well,
Thank you.
let me.
No, we're done.
Okay, that's fine. I'm not asking any more questions. I want to make a record here, if I may, Mr. Curry. I think that your instructions not to answer numerous questions are improper and unfortunate, particularly in light of these new documents that were just discovered. The judges repeatedly suggested that we should. There's a likelihood of having follow-on discovery after e-discovery. I think that it's improper, and I think that you're obstructing our ability to get to the bottom of these critical and highly damaging documents. And I'd like to put you on notice that if you don't allow us to continue to ask questions now or at a subsequent time, that we believe that you will be obstructing our ability to obtain evidence about improper discovery abuses by your client, and that you will be aiding and abetting in those discovery abuses. And I ask you to reconsider and permit us to ask Mr. Tatey these questions.
Take your threats and put them where you know better.
I'm not making
We're done.
threats.
Yes, you
Mr.
are. Just tell it to somebody who cares. See you Wednesday. Same step and my usual order.